Good afternoon. My name is Doug Powell. I'm an attorney here in Austin, Texas. I'm here to talk to you this afternoon about Chapter 7 bankruptcy and weigh through some of the pros and cons associated with filing a bankruptcy proceeding. This seminar is sponsored on behalf of Texas Legal, which is a statewide nonprofit legal benefits plan, which you're probably a member of, which is why you're tuning into this webinar today. I'm here to talk to you a little bit about Chapter 7 bankruptcy and understand what it does and what it doesn't do and how it might be able to help you and resolve any situations that you might have with financial issues or things along that line. Now, a little bit about me. I'm a 1981 graduate of the best university in the state of Texas. That's right, Texas A&M University. Graduated from the University of Houston College of Law in 1984. Upon my graduation, I began a legal clerkship in the United States Bankruptcy Court for the Eastern District of Texas. Up in Tyler at that particular point in time, started off with Judge Huffstetler, who retired about 18 months into my term, and then I finished out my term with Judge C. Houston Abel, who went on to be the chief judge of that district as soon as Judge Huffstetler retired. I'm presently board certified in Consumer Bankruptcy Law. I've held that certification since December of 1990. My certification is good through December of 2025, so I've got about 4 more years of that left. I've been out in private practice since 1986, and I founded my own firm in 1990, and I've been here in Austin in the same building on West 10th Street since 1991. I have a lot of clients that come back and they can't remember my name, they can't remember my face, but they remember my building, and they come back and we visit about their situation again. So I'd like to start off today's discussion with a short passage from the Bible, from the Old Testament book of Deuteronomy. We're talking about chapter 15 at this particular point, verse 1. And it says, and I quote, "At the end of every 7 years thou shalt make a release, and this is the manner of the release. Every creditor that lendeth aught unto his neighbor shall release it. He shall not exact it of his neighbor or of his brother, because it is called the Lord's release. Of a foreigner thou mayest exact it again. But that which is thine in thy brother's hand, thine shall release." In many respects, that's widely regarded to be one of the first bankruptcy statutes. It's a concept of releasing debts to understand that after a certain period of time, a debt's not going to be collectible. In this case, it also deals with property, which the modern bankruptcy code does not deal with. You don't release property if you have a valid lien or a valid claim of ownership. You keep that claim of ownership even in a bankruptcy proceeding. But I think it comes across with a really good point, which is good today, and that is never loan anything to family, because you're going to never get it back, whether it's 7 years or not. I think that's good advice even for today. Now, by today's modern statute, the bankruptcy code, it's 8 years between releases, which is a discharge that you obtain when you file a bankruptcy proceeding. We'll talk a little bit more about that later on. In the previous iteration of the bankruptcy code that was changed in 2005, it was 6 years. So it's moved around a lot over time, from 7 to 6 to 8, but the concept is about the same. About every 7 years, you can apply for a release and get out of the debts that you're looking at this point in time. In the scriptural passage, it contains one exception to that release, and that is if a debt is owed by a foreigner. You don't have to release it if there's a foreigner, but if it's your neighbor, or I suppose a member of your synagogue back in those days, you would not be able to collect it again. You could have a foreigner, though. And so that's kind of an interesting concept in terms of how this whole thing got started. It's a very old concept, been around a long time. So the next thing is, I look at this from a consumer bankruptcy practitioner standpoint. I file lots of bankruptcies for individuals filing Chapter 7 on a day in, day out basis. And I start off and I start my investigation as to whether or not a bankruptcy should be filed. And I look at 3 things up front. And the first thing that I look for is whether or not the individual involved owes enough money to make it worth their time to file. And then whether or not they have the financial wherewithal, that is, they have to pass the means test and the budget test looks right. And then the final part is, are they going to lose any property when they file bankruptcy? They need to know what the risks are. Now, when a couple or an individual comes in to see me about filing a bankruptcy, what they're really looking to do is they're looking at doing three things up front. And the first thing is they're looking at filing a lawsuit under the federal bankruptcy code. And they're suing all of their creditors under this bankruptcy code. And they're saying that under the bankruptcy code, the U.S. bankruptcy code, I don't have the ability to repay these debts as they have timely matured. I'm therefore asking the court to grant me a discharge. And a discharge is a magic word. The debt is discharged in bankruptcy, just like the old scripture release that we were talking about there. The debt is discharged in bankruptcy. It can never be collected by the creditor again. They can't call or harass you. They can't make a written demand and send you any correspondence demanding that you pay the debt. They can't send a collector by to visit with you personally about paying this debt. And most importantly, they cannot file a lawsuit against you to attempt to collect the debt through legal process. It's discharged in bankruptcy. The debtor at that point gets a fresh financial start. That's the key element of the bankruptcy code. You get a fresh start from your debts and you get to start over again. Now, let's say you are an individual, you file a bankruptcy and a year goes by and now you win the lottery and it's going to make you sleep better at night to write these guys a check and take care of them and pay them off. Then, yeah, you can pay that off with no problem at all and they'll be happy to take the money. Amazing what happens to your credit report. It does that too. Now, as I mentioned earlier, in the Old Testament passage, there was only one exception to getting out of the debt, and that was if it was a foreigner. Okay, well, today there's over 19 exceptions enumerated in the bankruptcy code as to debt that does not go away in a bankruptcy proceeding. And that ranges anywhere from taxes that you owe the IRS, to child support or alimony, to student loan debts, to debts incurred by fraud or misrepresentation, to a debt that you incur when you injure someone while operating a motor vehicle or a boat under the influence of alcohol or drugs. There's a whole litany of them under 11 U.S.C. Section 523 of debts that don't go away when you file a bankruptcy. Most people don't have those problems. The average person does not. And so it's usually not an issue to get rid of most of these debts. Now, when you say you're getting rid of the debt, you discharge the debt, you get out of the obligation, but to the extent that there's a valid lien in place, that lien remains enforceable. So you may not have to make your car payment anymore. It's true, but the car creditor could still come repossess the car if you don't. They have that right. Their lien on the title is not extinguished. Now, if they sell the car for $10,000 less than what you owe them, they can't come back and collect. It's just written off into bankruptcy. But they have the right to repossess the car. They have the right to foreclose on the house if you don't make the payments. You don't get their collateral for free, unlike our Old Testament passage that we looked at with the brother's property. Now, in another sense, you have to be very honest. You have to be very candid and very forthcoming with the information that you submit to the bankruptcy court. 11 U.S.C. Section 727 lists a whole plethora of things where your entire bankruptcy can be disallowed for misconduct on your behalf. One of the best ways to do that is to file knowingly false schedules. When you file information and it's with the court, it's done under the penalty of perjury. If you file false information, it's a problem, and they can say, well, you're committing fraud, so you don't get a discharge in this bankruptcy. Can't be done. And the final part of some of the basic information about bankruptcy is that you can reaffirm a debt. And that's really important on things like cars and houses that you want to keep. If you're sure that you can afford the house, if you're sure that you can afford the car, you want to keep them. It's important to reaffirm those debts from a couple of perspectives. And the first one is the law says that you're supposed to. That's really important. And then the next one is that it allows the creditor to report your timely payments on those debts in such a way that it helps you begin to rebuild your credit report. So that's really important too. You want to have your credit recuperate after you file this bankruptcy. Now, the bad news there is if you end up not being able to afford the car, then the creditor can come repossess the car still. They still have that right under the law, and they can sell it for whatever they can get for it. And if there is a deficiency balance, they can come back to you and collect on that amount. So it can be very serious if you take that step. I, as the lawyer, looked it over very carefully to make sure that you can qualify for this, that it's really in your best interest. As an example, I will not sign a reaffirmation agreement on a mobile home. I don't believe they're good deals. I don't believe they're the right thing to do. The mobile home company will not come repossess if you maintain current status on payments. But we all know how mobile homes depreciate very quickly. And you've got a 30-year note, and 10 years into the note, the mobile home's falling apart. If you filed a bankruptcy, you can walk away with no problem. You have to be careful about your vehicles. Ford Motor Credit, as an example, enforces these things very seriously. If you don't reaffirm the debt with Ford, they're going to come repossess their car. Other lenders, not so much. They'd rather have the payments. They're willing to take a chance, especially if there's insurance. So those are some of the highlight points on that. Now, like I say, when somebody comes in to look at my filing a bankruptcy with me, I start off and I look at three things. And the first one is, do you have enough debt to really make it worth your time to file? There's some people that come in and they only owe $3,000, $4,000, $5,000. And we have a nice conversation, and then I tell them they don't really need to file bankruptcy for that amount of money, and I send them along their way. But it depends on the situation. If you're a minimum wage level individual, if you don't have the financial wherewithal to make these payments, and a creditor is blowing your life up, it may be worth it to get rid of that harassment and make it go away. I won't say no summarily, but we'll have a long talk about the ramifications and the impacts and how it's going to affect you and what the price is going to be and whether it's really worth it, or is there another alternative to just ignoring them and moving away. So we go through the amount of debt. That's a really, really important factor. And my job as the attorney is to find out what the debt is. My job is to prepare the documents that you're going to be filing with the court. And one of the things I have to do is I have to determine everybody who's out there that thinks that you owe them money. Most people come in and they have a pretty good idea. And usually the idea is the people who are blowing their phones up the most with harassing telephone calls. But that's usually not everybody who's looking for money. Since bankruptcy is a notice-based system, I have to give them, the creditor, notice that you're filing bankruptcy so that they know to leave you alone and quit making phone calls to you. One of the ways I do that is I ask the clients when they start coming in to see me to start collecting their mail. If somebody's sending you a letter that says, hey, you owe us money, pay up, start saving that letter. Most people start throwing them away because they just don't want to deal with it. And I certainly get that. I need it because it helps me with a couple of factors. If there's a collection agency involved, I give them notice of the bankruptcy as well to help them understand to turn their harassing email machine or their harassing mail machine off. If there's a debt buyer out there who's now holding the debt for another credit card issuer, then I need to give them notice. And a lot of times the original creditor will be listed on there, Citibank or Chase or Wells Fargo. And I want to give them notice as well. I want to shotgun this thing out so that everybody gets a notice and everybody knows to leave my client alone. And so that way they get some peace back in their life, and that fresh start we were talking about earlier really comes to fruition at that point in time. It's not unusual that people forget creditors, whether that's intentionally or accidentally. There is a way to add them in later. It can be done. It's not always a good idea, especially to intentionally forget the creditors. We'll talk about that in a minute. But it can be fixed. It does cost extra money, but it can be fixed. It needs to be fixed as fast as we can. And so we want to make sure that we get all the mail that's coming in and try to capture that as best we can. The next thing I ask my clients to do is to get online. We ask them to go to www.annualcreditreport.com, and that's ANNUAL creditreport.com. At this website, you can generally get a copy of your credit report from all three major credit reporting agencies here in the United States once a year for free. We like getting those. They are free. You can download them generally as PDF documents so that you don't have to print them out. They're very large documents. They'll range between 50 and 80 pages. And we don't recommend burning the ink or killing the trees to print those things out. So if you can save them as a PDF document, it's very beneficial to us because we look at them as a PDF document. We go through them with a fine-tooth comb to make sure that everybody who's there that thinks that you owe them money is listed and taken care of. We can also spot potential issues with identity theft. We ask the client about all the debt. Sometimes the client will come and say, I don't know who that is. Maybe a victim of identity theft. Well, we make sure that those guys get listed down as creditors. We make sure that they all get reported in there so that they're all wiped out. Now, as an attorney who represents individuals filing in bankruptcy, I am officially categorized as a debt relief agency under Title 11 of the United States Code, Section 101.12a. I'm charged with a responsibility of making sure all the information that's provided to the court is accurate. And that means I've got to do my job and find out all the debts. And that's how the clients help me to do this. Now, everybody who files bankruptcy ends up signing a declaration under penalty of perjury. And it's an admonition in front of all the major signature blocks in the petition. And it says, quote, I have examined this petition and I declare under penalty of perjury that the information provided is true and correct. If I have chosen to file under Chapter 7, I am aware that I may proceed, if eligible, under Chapter 7, 11, 12, or 13 of Title 11 United States Code. I understand the relief available under each such chapter, and I choose to proceed under Chapter 7. I request relief in accordance with the chapter of the Bankruptcy Code specified in this petition, and I understand making a false statement, concealing property, or obtaining money or property by fraud in connection with a bankruptcy case can result in a fine of up to $250,000 or imprisonment for up to 20 years, or both under 18 U.S.C. sections 152, 1341, 1519, and 3517. Now, me personally, I'm not the one going to jail. It makes me look bad when my clients go to jail. I don't like it when my clients go to jail. And I try my very best to make sure that they don't. I've never had one go to jail. I'm going to keep it that way. But that means you're going to do your part as a client. You're going to come in here and you're going to tell me everything that's going on and let me figure out how to fix it and make it work right. The problem you have is if you don't list the creditors, you're potentially violating that admonition. And then you've got an issue where if the creditor doesn't find out about the bankruptcy, they're going to come back and say, well, I don't know nothing about no silly bankruptcy, so it doesn't apply to me. You've got to pay me anyway. There are ways around that. That's addressed specifically in 18 U.S.C. Section 523A3, but it costs extra money. If you list them in up front, it takes care of the problem, and we don't need to have that issue with us. Now, the real fine-tune is who needs to be listed. Well, the test under the Bankruptcy Code is if someone has a claim, and a claim is given the broadest possible definition, a right to payment, whether matured, unmatured, liquidated, unliquidated, contingent, disputed, etc., etc. So the bottom line that I always go with my clients is this. It's not whether you think you owe them money. It's whether they think or they might think that you owe them money, even though you would be thinking that they're full of it and you don't really owe them a dime. The way it's resolved, you put them down as a creditor and it's taken care of. And that's that. If you don't list them, we potentially run afoul of this situation. So for me, I'd rather overlist creditors and list too many people as creditors versus underlist creditors and leave somebody out and take a chance that they're going to come back and make a stink about it, because my clients generally can't afford to pay legal fees for me to come in and fix these types of problems. They're having a hard enough time paying the original fee as it is. So that's the first test right there. Do you owe enough money? How do you find out about the debts? Here's what the debts look like. So we've cleared that hurdle. Let's assume we've cleared that hurdle. There is enough debt to be worth talking about. Good rule of thumb is if you owe as much money as 1 year's gross annual salary, you probably need to look at it without saying it's a mandatory thing. So the next part of the test that when somebody comes in to talk about is income expenses. And this part is actually a two-part test as well. The first one is, are you going to pass the means test? And the second is, what's the real budget look like? So the means test was imposed in 2005 by the changes in the bankruptcy code that were made under the Bush administration. And they put in a test to measure the income of people to see whether people who were too rich were actually getting a discharge in bankruptcy when they really could and should be ordered to pay something back on their bills and debts. Now, as an example here, in Texas, a single individual, that's just no kids, with a median family income of less than $53,000 a year is under median family income. They automatically pass the means test. If you are a family of four, the test level is 89,196. If you have more children or there's more dependents in your household than four, you add $9,000 to that number per head over four. So you can have a pretty big number if you have a big house. The expenses get on up there too. So my first step is, where do you make, what's your gross income? Now the means test starts off, and we could spend literally an hour and a half talking about just the means test. It's super complicated. There's lots of tricks to it, and the United States trustee is always there ready to jump on you whenever you stub your toe on any of them. It's just their job, and they're good at it. But when you get to the means test, if you can pass the means test without having to break that number, that's good. If you don't, then you have to fill out the rest of the form and look at things like, what are your healthcare expenses? What are your telecommunication expenses? What are your vehicle expenses? Do you have any other secured debt? Things along that line. You can't just slop any old number into there, because if they see an unusual number and they know what looks normal, then they're going to ask you for backup. And you better have done your homework, because if you have not done your homework, if you don't have the data, they're going to file a motion to have your case either dismissed or changed over to Chapter 13. And it's going to make you look bad. Another way to make sure that you don't have to take the means test is if your debt is business-related debt. And when I say business-related debt, that's debt related to the failure of a business, not an unusual event in these COVID days. So if 50.01% of your debt is business-related debt, and that includes your mortgage, that includes your car, or anything that's personal type expenses, then you don't have to take the means test. You're automatically accepted from the means test. You're automatically accepted from the budget test, and you get to move along down the road. Now, again, you have to tell the truth. You have to come up with the right kind of stuff there, and you have to make sure that you have the right numbers in place. But if you're 50.01% business, no means test. If you're less than that, if you're over, then that's where we have to do our job and try to get you to pass it. It can be very, very challenging. And we spend a lot of time going over the means test in our office with our clients to see what it is that we can do. And sometimes it works, sometimes it doesn't. Most of the time it does. The last part is the Schedule I and J. They look at an actual budget on your part and they say, okay, you passed the means test, we'll let you go with that. And you're not a business case, fine. But what's the real numbers look like? So you're bringing home $3,000 a month, but you're living with your brother who doesn't make you pay any rent. You don't have a car payment. You don't have any utility bills. You only have to pay your own food. So in theory, you've got a surplus income of, pick a number, $2,000 a month. Well, you don't get a bankruptcy discharge with that kind of a surplus of an income. You've got to make a payment arrangement of your debts through Chapter 13. It's obviously not a normal situation. It does happen from time to time, but it's pretty rare. Most of the time, it's usually an error on the part of my clients when they come in and they tell me, well, gee, I don't have any expenses. And I'm like, okay, well, let's go through what you think you don't have. So you don't help out with food, and you don't help out with utilities, and you don't have a car payment, and you don't pay car insurance. By the time we go through the whole thing, they find out that, yeah, you know what? You're a normal American. You're spending what you make, and you make what you spend, and you don't have anything left over at the end of every month. So it's one of those things to where people go with that. And we help people get across that bridge to make sure that it's okay. But we do spend a lot of time on the budget issues, that's for sure. Now, the final thing that we go through with our clients is assets and property. What's on the table? What am I going to lose? What do I get to keep when I file bankruptcy? I don't want to lose anything. Most people don't have a lot to lose. We start off and explain very regretfully that anybody who files bankruptcy is going to be forfeiting their airplane. So for all of you people who are thinking about filing bankruptcy, kiss your airplane goodbye. Also kiss your bass boat, your ski boat goodbye. Yeah, I can't keep that in bankruptcy. Yeah, depending on how much equity you have in your house, you might not be able to keep any cash in the bankruptcy. Your vacation home, your rental property, all that's going to be taken away from you. And those mineral rights that Grandpa left you 20 years ago when he died, that are throwing off oil and gas royalty checks on a monthly basis, yeah, they're going to take all that away from you too. However, the average person that I visit with doesn't have any of that stuff. They're just getting by, struggling to get along and make it all work out. your home is safe. It's your homestead under Texas law. It's under your homestead under federal law. So you don't lose your homestead unless you want to. If you're upside down for whatever reason, I'll say, hey, you can't be in this market, but maybe you are, and you want to get rid of it, you can do that. You can give it back to the lender. They'll foreclose. Somebody will buy it at an auction for cheap, and that'll be that. You don't lose your car. You get one motor vehicle per adult licensed family driver. Most people don't have a lot of equity in their vehicles, though. And so it's a situation where the bankruptcy court doesn't take away vehicles that have liens on them because there's no benefit. You could sell the car, but you end up owing money to the creditor, and nobody wants to do that. And even if there was equity, then you still get the one vehicle to go back and forth to work, and there's no way around that. A normal amount of household goods and furnishing, IRAs, retirement accounts, 401ks, as long as it's less than $1 million, yeah, most people have that problem, are issues as well. You get to keep all of that. So there is a restriction on guns. Under Texas law, you only get to keep 2 guns. Most people have, if you have guns, you have more than 2, but it's usually something we can work around. And if there are non-exempt assets of that nature, usually you can make an offer to the bankruptcy trustee in your case to buy the assets back and pay them a little money for what they're worth, and you get to keep them without a problem. They really won't take the guns away. They don't want to have to sell them. They'd rather just have the cash. So that's generally not a big problem. Now, you need to make sure that all the assets are disclosed to the attorney, to me. If you're filing a bankruptcy with me, you need to tell me what you have, and you need to be as thorough about it as you can. I need to know what's on the table as much as you need to know what's on the table. And I can't really make those kinds of determinations unless you tell me what's there. If you tell me what's there, then I can fix it. I can tell you whether it's a good idea to file or whether it's not a good idea to file. I've had several people that have come in and there were assets that they would not lose. And we determined that a bankruptcy proceeding was not in their best interest, because if they were to file, all those assets would be on the table. They would be potentially taken away, and they didn't want that. But if you get surprised, you don't tell me about an asset. And I had a case like this one time where I had a long time ago where I had a couple that came in, and they didn't tell me that they had 3 duplexes. They just totally ignored it. And time came and time went, and 2 or 3 years down the road, they went to sell one of the duplexes. The title company pulled up the fact that there had been a bankruptcy and that they didn't get disclosed. And the bankruptcy trustee found out about it. He came in and he reopened the bankruptcy case, sold all 3 duplexes, paid off all their debt, and put money in his pocket, and then gave them a little bit of extra coming back. The surplus funds went back to them. But that wasn't what they had signed up for. And when they were asked, they specifically said that they had intentionally not told me. That potentially could have gotten them in jail, but because they took the money away and paid the debtors back, paid all the creditors back, they did not go to jail or suffer any criminal possibilities. They certainly could have, though. So from that perspective, it's really, really important to be very candid with me as a lawyer, to let me know I can fix it if you tell me up front. If you tell me on the back end, maybe not so much. We'll just have to see how all that works out. So the bottom line, though, is the average Texan here in the United States, the average Texan here doesn't lose any property when they file bankruptcy because they don't have anything to lose. They get to keep everything. Now, what's the practical impact of filing a bankruptcy? Bankruptcy, if you file a bankruptcy, it's going to show up on your credit report, and it's going to be there for a total of 10 years. What's that really mean? Well, it's going to keep you from qualifying to buy a house under FHA, VA, HUD qualifying guidelines as they are presently written. They do change from time to time, for a total of 4 years. You won't be able to buy a house. There are some 2-year programs that you can get into. They're not as easy to get into, and you'd really have to talk to your mortgage loan officer to see how you would qualify and see how that would stack up for you. You would start off planning on 4 years, but it could be only 2. Now, what's the next thing everybody in America needs to buy? A vehicle. Keeps you from buying a late model used vehicle for around a week, maybe. Depends on how much down payment you have. Now, you won't like the interest rate that they want to charge you when they see that you're filing a bankruptcy within the last week and that you need another car. Most of the places that I talk to are looking at 18%. Yeah. But in a lot of cases, I see people that's what they're getting anyway. Sometimes it's even worse than that, depending on which dealership you go to around town. Most of the time, filing a bankruptcy gets you down to 18% because a lot of those other dealerships are higher than that. But if it's a push come to shove emergency, your car's been totaled in a wreck on I-35 and you have to have another vehicle, you can get another vehicle. It's not generally a big problem. You may not like the interest rate, but you can get another vehicle. That's assuming, of course, that you can't get a family member to be crazy and co-sign for you and use their good credit that gets you a much better rate. But even out on your own, a little bit of a down payment, you're going to be able to get another car. Final piece of the puzzle, some type of consumer credit. Credit cards generally take an average of 2 to 4 years to come crawling back and asking for more. Not unusual that they come back faster based upon the amount of income that you make. You make 6 figures, they want back in your wallet a lot faster than if you're making $30,000 a year. That's just a fact of life. But I see people that come back in within 2 to 4 years, and they've totally rebuilt their credit. They're getting car loans at the premium rates, 2 and 3%. They've got a few credit cards that have come back. They're getting ready to buy a house. So it's not an end of the world kind of a situation. It can have an impact if you go for a bonded position, and that is one where there's a bond on your performance. Some insurance company has to provide a surety where you're handling cash or things along that line. Most of the time, it's not an issue. I've had some experience where people who worked for the federal government in sensitive positions, for example, prison guards out at the prison facility out in Bastrop, security screeners at the airport in Austin, they have their credit checked on a periodic basis because the thought that the government puts into it is that if you have bad credit, then you might be willing, desperate financially, to accept a bribe to allow somebody to smuggle a bomb or a gun onto a plane. So you can't have bad credit. And if you have bad credit, then you're not suitable for this job. And we're going to put you on probation. If you don't fix it, then we're going to fire you. But since this is federal law, Title 11 U.S.C. is federal law, availing yourself of the rights and remedies under the bankruptcy code is allowed, and they can't and will not fire you in that situation. At least the last time I had any contact and experience with those individuals. People would come in, they were threatened with the loss of their job, they would file for bankruptcy, and the threat went away. So that's an issue as well. Another practice tip that I give a lot of my clients, it depends on how much time I have and what their credit situation looks like before we come to file. I have some people that come in, their credit's still good, but they know that long-term and they're not going to be able to sustain it. One of the things I suggest, if they have the ability to do so, is that they go visit with a local credit union that they're not presently affiliated with. The rule in bankruptcy is if I owe you money or if you owe somebody money, I've got to list you as a creditor in my bankruptcy. But if I have a credit card through Randolph Brooks Federal Credit Union, and I don't owe them any money of any kind, no car loan, no signature loan, no credit cards of any other type, I don't have to list them as a creditor. They don't get notice of the bankruptcy. And as a result, they don't know I filed bankruptcy. They don't take the credit card away. And it's a way that I can use to rebuild my credit in a responsible fashion following the bankruptcy. Now, that doesn't work on a lot of other credit issuers. Chase, Bank of America, Wells Fargo, Capital One, just to name a few. They all employ what I refer to as a sentinel type service. And that is a sentinel service that literally monitors every bankruptcy court in America every day of the year, sometimes on an almost by the hour basis. And they find people who have filed bankruptcy. They take those people and they cross-reference them with their client's database of customers, names, addresses, social security numbers. And they find people who have filed for bankruptcy but not told their client about it yet. Well, filing a bankruptcy is an event of default under your credit card relationship agreement. And so the creditor has the ability and will pull your credit card, even if it's paid in full. You don't owe them a dime. Even if your payment history with them has been spotless, they will pull your credit card and discontinue allowing you to use it. And so now you're stuck with no credit by going to a credit bureau, a credit union first, one that you don't owe any money to, so I don't have to list them as a creditor, one that you don't use that credit card at any time for any reason until after the bankruptcy is over. You have a chance to pull something like that through. It can be very, very, very beneficial. So from that perspective, there are a lot of ways that Chapter 7 has both pros and cons, and that is The pro, of course, is that it gets you out of a lot of the debt. The con is it's going to have an impact on your credit. And there's just really not very much of a way that you can handle it any other way. But at the end of the day, when you complete the bankruptcy process, you get a fresh start. And with that fresh start, you get rid of all that debt. You get to rebuild your life again, and you get to move on. It can be a very beneficial tool for somebody who's approaching retirement. I see a lot of people that are getting into their mid to late 50s. They have a lot of debt. They're handling it okay now, but they can see that one of these days their health is or their ambition is going to play out. They don't want to work. They want to retire, and you can't retire if you're in debt. And one of the first things that you have to do is get rid of your existing debt. And by filing Chapter 7, you can do that. You get rid of the existing debt. That lets you then start devoting money to important things like 401k, paying down the house mortgage, fixing up the house as needed, things along that line. So it can be a very, very beneficial process. And like I say, I'm here in Austin. I'm Doug Powell. If there's something I can do to help you with something like that, please feel free to give me a call, and I'll be happy to help you as best I can. Now I'll turn it over. If there are any questions, or anybody would like to send me a comment or a question, I'd be happy to answer anything that comes along in that neighborhood. I don't see any questions at this point, so I'm going to sign out. Wish you the best. Let me know if there's anything I can do to help you. Thanks.